Welcome to the Business SOS podcast. This is Rich Sierra, president of the Florida Small Business Legal Center. This is episode 144 of Business SOS. Thank you for listening for the last 2.5 years and continue following the show. Hope the information that I provide to you is helpful to you and to your business. So last week we talked about the red flags in a contract and what to be aware of if you see different types of clauses. So today I want to talk to you about handshake deals or oral contracts or verbal contracts, verbal agreements. I see quite a bit of those. And it's very common that I get inquiries into my office that kind of read as follows. I enter into this verbal agreement with my friend to open a business. And I invested $50,000 into the business. And we were supposed to share the fees 50-50. Our profit was going to say a car wash business. He was going to work it, and then he was going to buy the equipment, get it started, the business started, and then I have not seen any profits, not any distributions. And he decided he did not put me in Sunbiz. I don't have access to the bank account, and now I want my money back. It's just one example. And again, some of those kind of give you an idea of the type of inquiries that I receive, and they're very common. That people are going into businesses on handshake agreements. Just with a few text messages, and I'm not going to go into whether text messages are sufficient to bind somebody. In some cases it is. But the premise is that people wire transfer money based on a conversation without having any documents, without having any type of agreement that is memorialized. Certainly no lawyers involved in this type of transaction. And when things go south, that's where they come to me, for example, as an attorney, to try to put the pieces together. My advice is that if you're going to go into type of business venture with anyone, do it in writing. And these types of verbal agreements or handshake deals happen usually with friends, with relatives, somebody that you know very well, somebody you have a type of familiarity or friendship, and because you feel, well, I don't have to really need to have an attorney or a contract because I know you. And it happens during the holidays. People get together, people having a good time, having a good mood, and they feel jovial, and they feel that there's might be a business venture they can do, and they talk about it, and then in January they start wire transferring money and getting started. And then there's no agreement in place to say, well, the agreement, we'll work on that later. Let's just get started right now. Let's not waste time on drafting an agreement with an attorney. In fact, we don't need a lawyer. We can do this ourselves. Let's save our money that way. I hear that all the time. And there's some problems with that, okay? One of the problems is that it's difficult to prove what terms you agreed to in a business venture if it's not in writing. Okay. You can have a conversation with someone, and yourself and the other person could have different interpretation of the same conversation. So to expect, especially in the business context, to two parties be on the same page and have a clear understanding what the terms are in a business, in a business contract or in a joint venture or in a partnership, it is difficult, if not impossible, because there's no document that memorializes the terms. So if you have a takeaway here as we go on into the 5 minutes of the podcast, that if you're going into any type of partnership, business venture, or any type of agreement, okay, that somebody suggests to you, we don't need to have an agreement, have a pause to it and insist on having an agreement before you invest any money or start working in that business. That is critical. And because by having the agreement, you will have those conversations that should be had before you enter into a business partnership in the first place. And in fact, I've made this available to my listeners. I have a partnership questionnaire that, you send me an email at richsierra.com. I'll send it to you. And what is designed is to really ask you questions about the business that you're going to be opening, who's going to be responsible for running the business, what are the responsibilities, who's going to be have authority to sign checks and for write or buy expenses for what amount, credit card use, okay, who has access to the bank account, who can hire and fire. I mean, all those decisions, all those conversations should take place before you go into a business with someone else. If you cannot get past that agreement and those conversations, then, in my opinion, you should not go into business. Or if you feel uncomfortable having those conversations with a potential partner, then you should not go into business with that person because it's not going to work out. Okay? You will have disagreements with your partner. That will happen. That's just inevitable. There will be some minor disagreements, may not escalate to a legal dispute, but people are not going to agree on everything, and that's fine. But when you have a situation where you are dealing with a potential legal matter and you go to an attorney, the first question that I ask, do you have an agreement? Do you have a bylaws? Do you have an operating agreement that I can look at? I wouldn't do one. We have some bits, but some bits not agreeing. Some bits are reporting. It's where you report who the officers are. Or we have some text messages. You can try to put together an agreement through text messages, but it's very difficult. So, in a type of handshake agreement or oral agreement or verbal contract, okay, it is difficult to prove what the terms were that you agreed to do at the time that you decided to go into a business venture. So that's number one. But it's also in the context of the work. I'm not talking strictly about a business venture. I mean, you can have an example of a painter decides to, they agree to paint, say, a house, the exterior of the house. Okay. But then, the homeowner says, can you do my driveway as well? Can you, pressure clean the driveway and seal it for me? The painter says, yes, I'll do that. Okay. But when the painter gives the additional invoice for that, the homeowner says, I thought that was included in that painting the house. No, that's something additional that was not included in that initial quote. So that's where the disagreement comes into play. The homeowner believed that additional work was included in the original price. The painter believed, no, this is additional work that I was asked to do, and I did it. Okay? In their minds, they're both right. The way they could resolve this is by the painter sending a change order to the homeowner. Hey, it's going to be this amount of money. And sign it or confirm via text or via email that you're okay giving you this additional invoice. We'll do this additional work for you. Is that okay? So always confirm in writing. You also have an issue of potential statute of frauds defense. And what is statute of frauds? Okay. Florida statute 725.01. Okay. The contract for any type of sales of goods over $500. Okay. The contract for real estate, even including lease agreements. Contracts that cannot be performed within 1 year, and contracts to answer for a debt of another, they're not enforceable. So as someone enters into any type of contract that especially involves like lease agreements or real estate, it cannot be a verbal contract. It has to be a written contract, otherwise it's not enforceable by state law. So you could run into that as well. And I think you got my point regarding the why contract handshake agreement is not a good idea. But I'll give you more examples. Okay. And I see this also in, website development. Now it's app development. Uh, any type of service business, I see this often, which is the scope of expansion and the shifting of expectations. When you agree that you're going to be doing something, and all of a sudden the scope expands, but it is not clear how you're going to get paid, or there's no definition of exactly how the terms will be made. And that's when you have an issue. And I'll give you an example. In a case of an app designer, they agreed to build an app for a restaurant, say for $5,000. And it's basically a simple design. You can make reservations, nothing else. But throughout the progress of the app, the restaurant owner wants that app to be able to do online ordering, to be able to do reviews as well, to do social media management. So there's a little bit more involved with this initial app. And the app designer, because she values the relationship, say, yeah, I'll go ahead and do it. So when the app designer sends the additional invoice of, say, another $5,000, top of the initial $5,000, the restaurant owner says, no, I did not agree to that. Okay. Again, the mistake again is not sending that change order or changing the scope of work to make sure that is clear that the restaurant owner agreed to pay for that additional work. And I see that very often when especially with work that is done on residential facility and residential homes, also in commercial properties, contractors doing work, and then they ask verbally, hey, can you do this for me? I'll do it. They send the bill, say, well, I never agreed to that. That's not what I agreed to do. And it's because of the relationship. My advice to you when that happens is that it's better sending an email or a text. This is going to be the amount. Would you agree? You get a yes, you get a no. That is binding. Okay, that will be sufficiently to bind and say, you agree to this. Here's the text message. Okay. I mentioned this before, but I want to touch upon again because I've dealt with this and it's very important. When people go into handshake deals, verbal agreements, especially in the context of a business venture, people go with great expectations. People go with tremendous amount of goodwill and anticipation that things are going to go well. I don't know anybody that goes into a business thinking that things are not going to work out. Okay. But and especially when people know each other, they're friends, they're family members, they're longtime colleagues, people that have known each other for years. And what happens is as time goes by, the relationship changes, people's priorities change, and expectation changes. And what happens is that there's a change in expectation when you have one business owner believing that this other partner is going to do 50% of the work, but in reality is doing 10% of the work, while the other one is doing 90% of the work and only getting paid 50% of the profits. And that's where the rubs come in. That's where the conflict comes in. And I've seen it very often, especially when you don't have a operating agreement. I see it with an example of happened many years ago of a case that people were, investing money to flip homes. Okay. And they were buying homes, remodeling them, selling them. But one partner was carrying most of the load. One partner was carrying, not only doing the repairs, working with the contractors, he was also doing the selling of the property. Well, the other partner was not doing much for the business. So clearly, and then while the other partner was also collecting significant amount of the revenue. So clearly there was a rub there. And in this case, there was no operating agreement in how to resolve the dispute. So what we had to do in this case is you try to recreate what the terms were based on practice. What do you do in the past? What have you been doing in order to try to recreate that partnership agreement? Eventually, the matter went into state court and eventually got resolved through mediation, attorney negotiation. But if there would have been an operating agreement with specific guidelines about who's responsible for what, that would have resolved a lot of issues. And I know there are templates out there that you can download from the web. Now you have various AI models that can help you create a program, some type of partnership agreement, but these are templated. I like the operating agreements or partnership agreements that I draft to be specific about what each partner is going to do. What are the expectations? But that will avoid a great deal of problems. And not having an agreement, and especially dealing with family members, dealing with friends, it can create chaos because you're dealing about relationships that could be broken, families that don't talk to each other, friends don't talk to each other for years because of misunderstanding that could have been resolved. Yeah. No one should be offended if you say, you know what, I want to get this in writing. Let's just keep it clear, especially when you're starting a business venture. If you're starting out and the contract gives you clarity, and the contract keeps maintain that relationship in a friendly term. Not having one is a high risk. Not having a written contract is a high risk, and I highly recommend to have an attorney help you draft one. If nothing else, you can always have one-page agreement and say, this is the key terms that we have agreed to do preliminarily before we do a formal contract, but let's agree on the following terms. It can be an email. So this is what we're going to do. This is the type of business. We're going to call this business X, Y, and Z. This is what we're going to do. This is going to be a partnership. This is going to be my percentage of ownership, your percentage of ownership. This are your duties. This is how much I'm going to invest, how much you're going to invest. We're both going to be signatories to the account. You both have responsibilities. Neither of us can hire and fire without the other one's consent. Mm-hmm. I can go on and on and on regarding what terms you should have, but it's better than nothing. Okay, it's better than nothing to have an outline of what the terms that you agreed to do. Certainly, depending on the circumstance, each side should have their attorney. I know in many cases, in practical, I don't like representing both sides. If that's the case, I'll tell them I will only draft what you give me, but I'm not going to give either one legal advice. I put it in writing. Or if it's something that requires one side to get each side to get an attorney, then each side should get their own attorney to make sure that each side is independently represented in order to avoid conflicts of interest. And I know that you're going to say, well, that's more money that we have to spend in lawyers. I get it. I hear you. However, think about the cost of you trying to defend or sue your partners. Defend a loss from your partner or having to sue your partner. The cost of hiring attorneys to help you draft a well-written, well-thought-out partnership agreement is minuscule to the tens of thousands of dollars that you would spend defending a lawsuit or prosecuting one on a partnership dispute. So think about that. if you're about to spend, invest $50,000, $100,000 in the business, is it really that much money to spend $2,500 getting a contract well drafted? I don't think so. But many people decide that that's too much money for that. But they have no issue wiring hundreds of thousands of dollars on a business venture based on a handshake agreement, based on a telephone call. And the consequences are significant. So if I do anything today is to make you aware that it's not a good idea to go into oral agreements. You should always have it in writing. If it scares you a little bit, that's okay. I'm fine with that. Because if nothing else, you're going to be saving hundreds of thousands of dollars in many cases. When you don't have an agreement, written agreement, you also have no dispute resolution process, meaning that the process that you have to resolve the dispute is state court. Obviously, you have access to the courts, but by having an agreement, you can have a mechanism in place that creates a step before going to court. That's called mediation. And I've spoken about the mediation often. In fact, I had Matthew for an hour here a few weeks ago talking about mediation. By having a step process, it allows the business owners, the partners, to talk about it with a third-party, neutral party. And in most cases, partnership disputes get resolved at that point. Very seldom they get into a litigation mode. They actually go into a lawsuit. So I like my agreements to have a step before, with some exceptions, of course, that you can have to go straight to court. But for the most part, most partnership disputes can be resolved through some type of mediation or attorney negotiation, so it does not escalate. I mean, you were partners, obviously for a reason at the beginning, so there's no reason to try to go straight to court, and that should be the option of last resort, going into court, going to lawsuit, because it escalates significantly, and I've talked about the cost of going into litigation if you decide to do so, or if you have to defend it. It can be tens of thousands of dollars. And then sometimes there's no end to it unless you decide that's the end. Another example I want to give you, which I see that often, is with lease agreements. And I always go back to lease agreements. Simply, lease agreements is one of the most common agreements, the likely agreement that you're going to be signing for your business unless you own the building or you work from home. You will have some type of lease. So what happens is this, and this happens when the owner of the building might be an individual. It's not a management company. It's not a large corporation. This might be somebody that owns a small, 3 or 4 unit strip mall, and the owner is involved in managing it. It doesn't have a professional management company handling it, because they handle things a little bit different than an owner. So you're there as the tenant, and then you say you're a little bit late in rent. Okay. Things are not going well and your business is slow. You begin to pay your rent, 15 days, 20 days late. Okay. And that happens very often. Okay. And the landlord, is okay with that. The landlord says, you know what? Okay, pay me, I'll take the late payment. But he doesn't do anything about it. He doesn't send you a bill for the late fees. A year later or 2 years later, the landlord sells that business, sells the building to somebody else. Okay? And maybe it's a management company. So as they're doing the audits of their payments, they realize that you're paying late. You have been paying late every month for the last year, maybe 2. You get a bill for late fees for the last 2 years. That could be a few $1,000s. And then you come to me. and say, "Hey, I got this bill. The landlord was okay. He sold the building, but he never had an issue with me. He knew things were slow in my business, so I was paying him on the 15th of the month as opposed to the first. He never sent me an invoice. Never sent me a bill for late fees. And I'm getting this. He sold the building. Now I'm getting a an invoice for $5,000. What should I do?" Well, the answer is you got to negotiate that out. You can try to negotiate that out, but most likely you'll have to pay it because the landlord never changed the terms of the agreement. The landlord simply accepted the payment, but he did not change the lease. So if there's a situation whereby there's a change in the terms of the lease, any contract, that should have been done in writing. So that way you don't get a retroactive invoice for late fees. And I just give you, that's one example. And there are many others that I can give you. But it also happens when you're talking about fixing items in a property as well, in terms of leases, that the landlord allows you to put a sign. They didn't say anything about it. The new company comes in and says, you got to take that sign down, or painting the place, whatever it is, have it in writing. And I'm hammering that throughout this, 30 minutes that you spend with me. So one of the things that I like to see in contracts, I like to see some type of notice that if there's a breach of notice requirements and an opportunity to cure. A lot of times would not notice in a opportunity to cure, say 15 days or 10 days, things get resolved. So anything that has a notice that allows the other party to correct the deficiency is helpful because it creates a stopgap before going into full-blown litigation. So I do like that. And I do like mandatory mediation before going into arbitration or litigation. That's my preference, simply because if business owners are given an opportunity to resolve the matter beforehand, then there's no need to spend tens of thousands of dollars in attorneys trying to resolve the dispute, then to go back to mediation and resolve it after you spend tens of thousands of dollars. So it doesn't make any sense. Okay. So in terms of going into business, I want to give you some thoughts or thoughts about this podcast, this topic. When you're asking for written agreement from someone, it's not that you don't trust them. Don't feel that it's a sign of distrust. It's a sign of keeping things clear. It's also a benefit to everyone, okay? And that you're taking the business seriously. And especially when people know each other, it's good to have a written agreement to keep clarity and what the terms are. And if you cannot agree with the terms, then maybe the business venture or whatever transaction you were contemplating, it might not be worth it. One, simple written agreement or a term sheet is better than nothing. So if nothing else, have a term sheet, have an email that's a bullet points, this is what we agreed to do. You're okay with this? Yes. So at least we have something to work with. It's a good idea to have it memorialized in a more formal document, but absent of anything, that's better than nothing. I will discourage you from doing agreements via text or WhatsApp. It's just very difficult to put them together and to understand what you actually agreed to do. The context of a text message is difficult, so I would discourage you from doing that. And leave you that, you will not build a house without a blueprint. Every structure that we had a blueprint beforehand. So a business relationship should also have that blueprint. A business should have a blueprint. So if I leave you with that, is that, when you go into business, do it with a contract, do it with an agreement, spend the money to get it done right, because it'll be money well spent. This is good for today. I truly appreciate you listening to this podcast, and this is episode 144. 5 things that could go wrong with a handshake deal. Hope this was helpful and informative to you. If you have any questions about this topic or you want to send me an email, My email is rich, R-I-C-H, at richsierra.com. Again, rich at richsierra.com. If you want to learn more about our legal services, my website is floridasmallbusinesslegalcenter.com. Again, floridasmallbusinesslegalcenter.com. Check out my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble. You could ask for it at your local bookstores as well. If you want to give us a call, my number is 866-842-5202. The video of this podcast is also on my YouTube channel, youtube.com/@Richard Sierra. Until next week, this is Rich Sierra. And remember that my goal is to help you succeed.